Hi, thanks for using my court coach. My name is Sarah and I'll be your instructor today as we discuss how to address imputation of income in court. Family Code Section 4058 governs and authorizes the imputation of income to a party for determining child support purposes where it's found to be in the best interest of the children. However, how do you actually ask the court to do this? You can, quite simply, ask the court orally when you're in court for this relief. Family Code Section 217 states that at a hearing on any order to show cause, and those are now referred to as requests for orders, or notice of motion brought pursuant to this code, and absent stipulation of the parties or a finding of good cause pursuant to subdivision B, the court shall receive any live competent testimony that is relevant and within the scope of the hearing, and the court may ask questions of the parties. So technically you can bring this up for the first time at the hearing. However, I find that it's much better practice to actually include it in your moving papers, your declarations, also known as your pleadings. And this puts the other party on notice. There is a competing interest, and that is the other party's due process right to have actual notice and an opportunity to participate and respond in the proceedings. And I think there's a strong argument to be made that if you've never raised the request to impute a party with income prior to the hearing date, then you're violating that party's due process rights. And at the very least, it can lead to a continuance of the hearing to allow them opportunity to respond. What happens, however, when you are not entirely aware of the other party's financial situation other than a short time prior leading up to the hearing? There is the option of filing what's called a supplemental declaration. And this declaration would supplement information previously provided by you to the court based on newly acquired information. I do think, particularly if you are requesting a vocational evaluation, that it's not a terrible idea to file a whole separate request for order specifically requesting that, and then there can be no argument that the other party did not have notice of your intent. So in short, you do not have to raise this request for imputation of income prior to the hearing. However, it is your best practice to do so. I hope you found this helpful. Good luck.